We are on the record.
All right, thank you. Good afternoon, everyone. The Appellate Court for the State of Connecticut is now back in session. We will now hear the matter of BRAY versus BRAY, docket number AC 43309. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Cradle and Judge Pellegrino. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances for the record, let me alert or otherwise remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, kindly remember to be careful not to disclose such information during argument. I would now ask that everyone participating in this hearing identify themselves for the record, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall.
I'm Judge Cradle.
I'm Judge Pellegrino.
Attorney Adam Teller representing the appellant defendant, DWAYNE BRAY Sr.
Chris Creason for the plaintiff appellee, NATALIE BRAY.
All right, counsel, prior to this proceeding, you should have received procedural instructions. Do you have any questions with regarding those instructions?
No, Your Honor.
I do not.
Okay, and a few additional preliminaries. When you are not speaking, if you would try to remember to turn off your mic while leaving on your video. We want to ensure that we don't lose anyone. Also, let me state the obvious. Try to comport yourself as though we were in the physical courtroom, avoiding anything that might be distracting to the judges or to opposing counsel. Each side will be permitted 20 minutes of argument. I will endeavor to give you a 2-minute and 1-minute warning. The appellant may reserve a portion of that time for rebuttal. So Attorney Teller, are you ready to proceed?
Yes, Your Honor, and may I reserve 5 minutes for rebuttal, please?
You may do so, and go ahead.
Thank you. May it please the court, and good afternoon. This is an appeal from orders which were entered in a post-judgment divorce proceeding, contempt proceeding, and unusually in which the trial court made no finding of contempt, but interpreted the judgment in a way that neither party had proposed before or during the hearing. The court also ordered relief that the movement never actually requested. I'd like to crystallize that by highlighting some brief facts. My client, the defendant, receives both salary and additional incentive compensation from his employer in various forms. The salary, under the structure of this divorce judgment, the salary drives his base child support and alimony, and as with most salaries, as pretty much any salary, he has tax withholdings from them that are perhaps adjustable by him and are related to his overall income. But the tax withholdings are irrelevant to what he pays in either child support or alimony. In other words, he could withhold nothing, or he could withhold more than he needs to pay his actual tax obligations. But under the structure of this agreement, they don't change his alimony or child support. He receives incentive compensation in various forms, one of which is cash bonus. Another is restricted stock units, both existing at the time of the divorce and awarded in the future. The federal withholding for tax purposes from those additional compensations at the time of the judgment was 25%. And for most of the years under discussion, it was 25%. It was not adjustable by him, nor in fact, in general by his employer. That rate is set by federal rules. It's now 22% under the tax changes that went into effect in 2017. It's completely clear from the record that those withholding from these additional compensation forms is not sufficient to pay his actual tax. His actual taxes, according to his accountant and according to his own testimony at trial, are based on at least a 33% marginal rate for the years in question, but the withholding by his employer was 25%. So the practical effect of what the court did here was that, taking, for the example, the existing stock options or stock that existed during the marriage but did not vest until after the divorce, known as RSUs or restricted stock units. Those were treated as marital property to be divided 50% to each party based on their net value, so-called. Well, those particular forms of compensation are taxed to him as ordinary compensation, so that when those RSUs vest after the divorce occurs, they are immediately sold and the 25% federal tax withholding is taken out. Now, if the division is taken at that point, each party effectively gets 37.5% of those of that check. Okay. But in fact, the defendant then has to pay, according to his accountant and to the evidence, an additional approximately 8% to make up for the 33% actual tax that he's paying. And remember, it's assessed on him.
So does the wife, if she's in a 33% bracket.
No, you're not so, Your Honor, because these are taxed to him as ordinary income at the time they are exercised. And they're being, in this particular case, they're being divided as marital property after that. So she simply receives what she receives. She pays no tax on it. In his case, he's paying at least with respect to the marital property division, the existing RSUs that were unvested but vested later. He's paying all of the taxes at the time.
But then he gets a deduction, doesn't he, of half?
Well, not in that case, because these are marital property, not alimony, so he gets no deduction.
All right.
For those items. So,
Attorney Teller, can I interject with a question, please? So if you were successful with your argument and the order is reversed, what does the remand look like? Can you help me understand that? Because it seems clear, having read the motion for contempt, that really none of it was granted, but there's this other order, and there are some references to it as a remedial order. But let's assume, for argument's sake, that we agree with you that the term was ambiguous and it was interpreted incorrectly. What would you have us do in terms of direction on a remand?
The case of where the court finds the agreement ambiguous is different from where the court finds it's not ambiguous, but upholds my version. But let's take that first case. In that first case, the court has a choice of two options. One, it can simply either reverse or eliminate the court's so-called remedial order and and stop the case there, because each party has the choice to then file a motion for clarification or make an agreement to clarify and then adjust the payments accordingly. If neither side does, I think my client would be entitled to credit for what he paid in compliance with the court's original order, now vacated or reversed. But the parties would go forward apparently still arguing about what the meaning of net is. And if you look at the record, it's clear that they've been arguing about the meaning of net with respect to these three kinds of compensations since very shortly after the judgment entered, notwithstanding that it was a judgment by agreement. Now, the second case, the case where the court believes that the term net is unambiguous, but agrees with me that it means net after actual taxes, then the court again would vacate or reverse the order, but send the case back for determination on the facts of what actual taxes means, or again, leave the parties to their own devices to either work out what actual taxes means or file a motion for clarification. The third possibility is if the court finds it's ambiguous, but feels that the trial court needs to make a factual determination of what the language means. That will require the party's testimony, and I don't think there is language or there is evidence in the record about what the parties thought it meant and why. But I think that probably it needs a new hearing on that issue.
Okay, thank you.
Get back to where I was. The threshold question here is that the court needed to determine what the parties intended to subtract from these various forms of compensation when they used the word net as a driver for what the defendant was supposed to pay the plaintiff. And I made this point in my brief, and I think it bears repeating because most lawyers are not natural mathematicians. The word net, in the context of where you're using it to try to figure out what happens with money, is the verbal equivalent of a minus sign in a mathematical expression. It does not import any information whatsoever about what's to be subtracted. It's simply the minus sign. We're talking about a part of the whole and not the whole. In order to find out what these parties intended to be subtracted, you have to look at the context and the purpose of their agreement, meaning that it's a divorce agreement. It's not a promissory note or something else. You have to look at the surrounding text. You have to look at the common usage that was in effect at the time. And I would argue that you also are entitled to look at their conduct after they reached this agreement and what they did afterward. And if you do that in the question about whether this agreement is ambiguous or not, I submit to you that there are at least two reasonable interpretations of the word net as it's used here, and I alluded to them. One is that net means whatever the defendant gets in a check after his employer has taken withholding. The other is whatever the defendant is actually left with after he meets the tax obligations created by this income. Either one of those is possible. One's, I submit, more reasonable and more believable than the other, but they're possible. The court chose the first version. The problem with the first version is it doesn't meet any of those things that I talked about earlier. It doesn't meet the context, because the context is that some of this money is alimony and some of it is child support. And the case law is clear that alimony and child support are supposed to be paid from net available money, not just the money that you get in a check from your employer, but you're supposed to look at all of the possible exemptions, deductions, and credits when you do child support. That's straight out of the child support guidelines. The Sunbury case, the Collette case, all talk about what people have as available spending money. And it's not available just because you pay your taxes in installments. You pay 25%, or in this case, currently 22% out of this income when it's actually dispersed to you. But then at some point during the year or at the end of the year, you've got to pay an additional 8% or maybe more. And it's very clear from the record that both parties recognize that the actual taxes from these forms of compensation were substantially more than the withholding. The defendant presented actual evidence from his accountant himself that his effective tax or his marginal tax rate was 33%. The plaintiff submitted argument in a brief that argued that the effective tax rate was somewhere around 26 or 27 or possibly 29% in some cases. So it's quite clear that if the employer is taking out 25 or now 22% under the current tax code, that the defendant's actually paying more than that. And what he has left to pay the resulting child support or alimony obligations is therefore reduced. Now,
Attorney Taylor, you have 2 minutes left, but let me interject with a question here. Was there any evidence as to what the defendant's effective tax rate was?
There was no evidence offered or or admitted as to the defendant's effective tax rate, and keeping in mind that the plaintiff bore the burden of proof on every issue of fact, and that the court did not actually find that he was in contempt. Now the question is, what could the court have done as an equitable matter to enforce the judgment? And I submit to you that if there's any failing of proof as to any important fact to find out that what the defendant should have paid under this judgment, the plaintiff bore the burden of that proof, and therefore, if there's no evidence as to effective tax rate, the court couldn't make an award or an order that he pay to accommodate an effective tax rate. There was, however, indication in the plaintiff's brief that they conceded that the effective tax rate was more than 25% or 22%, as it might later have been withheld. I think the case law clearly recognizes that net by itself is ambiguous. There are numbers of cases which use net in various versions: net revenue, net proceeds, net professional income. And in each case, the courts have pointed to the need to specify what's to be subtracted. And if it's not specified, then it's ambiguous. So I submit to you that that pretty much ends this court's job here, is that it's ambiguous, and the case should be either the order should either be vacated or sent back for further proceedings. Thank you.
All right. Thank you. All right, Attorney Creason.
Thank you, Your Honor. Again, Chris Creason for the plaintiff appellee.
And I'm sorry to interrupt you, but Attorney Teller, if you wouldn't mind turning off your mic. Thank you so much. All right, Attorney Creason.
Thank you. For the plaintiff appellee, NATALIE BRAY, I do just want to recognize there were two certified legal interns on the brief, Ching-Wei Wang and Emily Covey. So I'll say that anything that you liked in the brief, I'll give credit to them, and anything you found lacking, I'll take responsibility. You might think that this case involves a math problem, and happily it doesn't. It's a simple question of a contract interpretation, and the interpretation is focused on one word. What does the word net mean? And there's sort of two arguments being made before you. One is that this word has a clear and unambiguous meaning. That's important because that means that your review is plenary. The second argument that's being made is that the word has an ambiguous meaning. I think that means that there was fact-finding at the court below as to the meaning of the word, and then that means that the standard of review this court has is a deferential one, and I think it can only reverse on a plain error finding. I want to go straight, Judge Mahl, to the question that you asked about whether there was any evidence of the defendant's actual effective tax rate, which is probably a redundant statement. But I think that question actually goes to the core of what's before the court here. And the reason is there's two questions. One is, what does net mean? And then once we decide what net means, how is the net calculated? And of course, the net can only be calculated based on the evidence that was before the court. What the court had below was a testimony of a withholding rate by the employer of 25%, and the testimony of an accountant that said the defendant has a marginal tax rate of, I think, 33%. And that's it. That's all the court had. And that was sufficient for the court to find as it did. So for the appellant to have this court reverse the lower court, it would have to find that evidence was insufficient to support the court's finding, and it clearly was sufficient. So just going back, I want to focus a little.
Attorney Creason, can I ask you a question at that point?
Please.
So, do you agree with the idea that the trial court did not adopt the plaintiff's theory as to what net meant?
So yes and no. So in the meaning, yes. In what the net application was, no. So the court accepted that net means income after taxes. All right, just as counsel described, net means minus. But then what the court did is rather then argue that it was the effective tax rate. She found that the net rate was what the court, what was being withheld by the employer. So and I hope that answers the question, because it's, what does net mean? It means income after your tax obligations. And then once you know that, then the accounting begins to calculate what that is. And the plaintiff had a argument.
I'm sorry to interrupt you again, but I'm just trying to understand these various theories that were at play. It seems to me that the trial court rejected both parties' theories and then came up with its own theory, which is net is going to mean at the time of, for the lack of a better word, payment, whatever is left after ESPN withheld 25%.
Correct.
End of story, right?
Exactly.
But there was no testimony, at least to my understanding, that 25% represented what the defendant paid by way of taxes under anyone's theory, right?
Correct.
So then how can the order stand?
Because the argument is different from the evidence that was before the court. So, and that's why I went right to your question, Judge, about whether or not the actual effective tax rate was before the court, because it wasn't. So what the court had was testimony of a employer withholding of 25%, and it had the testimony of an accountant that said the defendant's marginal tax rate is 33%. That's all the evidence the court had to rely on. So even though the parties made arguments, arguments, of course, aren't evidence, the court had to make a decision based on the evidence that was before her. You're probably thinking it would have been really nice if the defendant's actual tax returns were submitted, and then the court could have looked at them and seen what was the actual effective tax rate for each of these different forms of income, because the different kinds of income have different tax rates. And I think one of the arguments that the plaintiff has made is that the net rate, the net applied separately to each income results in a different tax rate, and that is absurd. My analogy to that, it's like saying that a thermometer doesn't work because it records different temperatures at different times of the day, right? It's doing exactly what it should do. The net varies according to what the tax rate is, which varies according to the kind of income and the year of the tax code that's in place. So to go back to your question, Judge, the court heard arguments which aren't evidence and made a decision. One, what does net mean? Decided that's a plain and unambiguous word, and then applied it to the evidence that was before her, which was two choices, a 25% withholding rate, what's left after that, or a 33% marginal tax rate. And I would say the reason the court didn't accept 33% as the number she should use is because that was hypothetical. That's what is.
Isn't the third option that the plaintiff didn't satisfy her burden of proof to show what the effective tax rate was if that was the theory that was ultimately adopted?
That's an option, I guess, if we're going to just look at what are the three possibilities. But the plaintiff, I feel like we're distinguishing between an argument that's made and the evidence that's presented. So if the plaintiff is arguing that the net should be what's left after taxes, and the only evidence the court has is these two options, I think it's sufficient to go with what's presented. I think what you're saying, Judge, is the evidence that was required to meet the standard wasn't there. And if that's what you find, then it means that this case goes back on remand for another evidentiary hearing where hopefully the tax returns, which would show the actual tax rate, would be introduced. But it still means that this court has to make a finding about what net means. Which
Counsel,
is, yes.
Is it an oversimplification to say that the net is whatever the husband receives after the employee deducts whatever the employee deducts? So it's what he received. I don't know why we have to get into tax rates. The employer has to deduct under the law 25%, I guess now 22%, but whatever the employee deducts is that amount, and whatever the husband received is the net amount. And that seems to me what the agreement says.
That's exactly what the court found. So
Right.
that's exactly what the court found. And,
Okay.
and we're, of course, looking for.
So is that theory one? Is that theory one?
I don't have the theories numbered, but that's essentially the argument.
Mr. Teller went through various numbers. I think that's one. Okay.
All right. He's far more sophisticated than I am, but I mean, my argument actually begins with the standard of review before this court, because the appellant believes it's plenary, and it's plenary only if the meaning of the word is clear and unambiguous. And if it's not, we get into a deferential standard, and you've got to find that the trial court reached a clearly erroneous decision. Okay.
Okay.
Was there another question, please?
Not for me. I'm fine. Thank you.
That actually covers all the points that I want to make. I mean, I think it's important for this court to understand the standards of review that are in play here, because that obviously dictates how much deference you give the trial court, and then understand that the question is, what does this word net mean? And if it's clear and unambiguous, then we just apply what's left after taxes. And then this question about whether or not the trial court, on the evidence it had, reached a correct decision. There were, just if I may, Your Honors, there were some things I was making some notes as counsel was arguing, and I want to make sure that I attend to them. No, I don't have it. So if there's no other questions, I think I made my points, and it's in the brief, and I thank you for your time.
All right, seeing no other questions, thank you. All right, Attorney Teller, you have 5 minutes for a rebuttal.
Thank you. Your Honors, the first issue here is that it's clear that the standard review as to whether or not the agreement is ambiguous is plenary, and that's the part that this court is in the same exact position as the trial court. You can look at the language and determine that just as well as the trial court is. And if you determine that it is ambiguous, that pretty much ends the issue, because the trial court didn't make a determination as to fact as to what this agreement meant. It made a determination as to law. And at that point, the case has to go back one way or the other. I also would like to emphasize that the court clearly rejected both parties' interpretations and theories of what the agreement meant. And not only that, the plaintiff never asked for relief that was based purely on withholding numbers. The plaintiff never asked the court to simply have the plaintiff restore the 8% that he subtracted, or restore the resulting calculation of the 8%. The plaintiff expressly asked for something based on a determination of effective tax rate, but then didn't offer any evidence to establish the effective tax rate. And to me, that means that the plaintiff asked for relief and then didn't prove her case as to what that relief should be. Remember that this case arises in that unusual situation where the plaintiff filed a motion for contempt and didn't win. So the only power the court had was some penumbral power to enforce the judgment to the extent that the plaintiff was asking for enforcement. Well, if the plaintiff doesn't ask for a particular kind of relief, and there's no separate motion asking for that kind of relief, and there's no separate vehicle for the court to determine what the plaintiff is owed by the defendant, then doesn't the plaintiff have to prove what they asked for? Don't they have to prove that they established an effective tax rate in order to calculate what the court should order? And that's what's lacking here, is that the plaintiff asked for a particular relief. In every instance, they asked for relief based on an effective tax rate, but then the plaintiff put on no evidence of effective tax rate. So how is it justice, which is what the court is supposedly doing when it in this penumbral area when it enforces a judgment? How is it justice to order the plaintiff or order the defendant to pay something which the plaintiff never established the correct amount? And the only way the court was able to do that was because it reverted back. It reverted back to what the employer had withheld. But the only thing that is clearly proven in the case is that what the employer withheld is not necessarily what the actual taxes are. Both parties agreed that it wasn't what the actual taxes are, because otherwise there wouldn't have been any need to argue about that. Thank you. I give the rest of the time back to the court unless the court has any questions.
All right.
I'm
I
fine.
don't see any other questions. So counsel, thank you for participating in this virtual format. The court will take the matter under advisement and will stand in recess until 4 p.m.